Mo Hashim here with Flat Fee Landlord Property Management. We are a property management company that manages single-family homes in the Northern Virginia, Washington, D.C., and Maryland areas. And I want to go over the number one question we get, which is how to evict a tenant. Now today I'm going to focus on Virginia. D.C. and Maryland are going to have their own steps on evicting tenants, but in all intents and purposes, right now I'm going to go over how to evict a tenant in Virginia. So you may be in the process of needing to evict a tenant, or you're thinking about renting out your property and your number one concern is, hey, what if the tenant needs to be kicked out or evicted? What's the process? I'm about to go over that with you right now, and hopefully at the end of this you'll see that it's really not that hard. At least the myth is that it's super hard and complicated, and I've kind of found from experience that anything that is foreign to you, that you've never done before, is going to seem hard before you actually do it. So I'll go over the steps. It's really not that complicated. If you have any questions or need any guidance, feel free to reach out to one of our offices at any time and we can certainly assist you. But the number one thing is, you want to get started. Before we even get started, is you want to make sure you have proper documentation. In order to make the eviction process simple, you have to have a valid and legal lease in place, and you want to make sure it's written. That's going to make it easier as well. So as long as you have that, the rest of the process should move pretty easily. So when is rent due? Rent is due on the 1st of each month, okay? In Virginia, typically we give a 5-day grace period. So after the 5th of the month, it's now considered late. Now, I will tell you the law, and I'll tell you what I would recommend as a landlord. If you have not received rent by the 5th of the month, before you really start threatening or go into eviction mode, I would reach out to your tenant and see what the issue is. It could be as much as, they thought they submitted it and for some reason it just didn't go through, or they sent you a check and it's lost in the mail. I know a lot of times we hear these excuses and we don't believe them, but if you reach out to them and tell them, hey, I haven't got the rent, a lot of times if they are stand-up people and you did a good job screening them and getting them in place, you're probably going to get a truthful answer that you can work with. So that's what I would recommend doing before you even go into eviction mode and going through this process. But let's say you exhausted all that and you're beyond that now, and you really do need to get these tenants out of your property. The first step is going to be to do what's called a 5-day pay or quit notice. And in this notice, you're going to basically tell the tenant that you have 5 days from the receipt of this notice to pay me the full amount of rent, or you have to get out of the property. And you have to deliver this in a couple of different ways. Here are the two that I recommend, and really one that I truly recommend. So number one, you're going to make sure you send it to every tenant that's on the lease, okay? So if you got 2 tenants on the lease, you can't send one 5-day pay or quit notice, combining both of those people on the same notice. You want to send separate notices for each person that's on the lease, even if they're on just one lease, okay? So that's number one. Number two, you can either send it by certified mail, or you can do what we typically do, is go to the county sheriff that the property is, the jurisdiction that the property is located in, and have that county sheriff deliver the notices for you. If you decide to go that route, you're going to want to show up to the sheriff's clerk's office with at least 2 copies of your 5-day pay or quit notice. And you need 2 copies because the sheriff is going to deliver one for your tenant, and then the other copy is going to be sent to you as proof of delivery that the sheriff either handed it to the tenant or they had to leave it on the door. So you need 2 copies when you show up to the sheriff's office. So that's step one, file a 5-day pay or quit notice. Again, what the 5-day pay or quit notice does is it gives 5 days from the receipt of the notice for the tenant to pay or leave the property. Is what that means. So it's not 5 days from when you file it with the sheriff or when you write it out. It's 5 days from when the tenant actually receives it. So you want to make sure you follow up with the sheriff's office if it's been a while since you've went to the sheriff's office, to have them deliver that 5-day pay or quit notice for you and you haven't received the receipt back in the mail yet, you want to follow up with them, because sometimes the sheriff's office does get backed up depending on what they have got going on, and it may be a week or two before they can even go out and deliver that notice. But typically they're pretty quick. They usually deliver it within 24 to 48 hours from the time you give it to them. But there are times, like I said, where they get backed up, and the timer starts when the tenant actually receives that notice, not when you drop it off with the sheriff. So now you've received receipt of the sheriff delivering it or of the certified mail, and you have 5 days. So the timer is on. After 5 days, if you still have not received payment from your tenant or the tenant has not left the property, at that time you want to file what's called a summons for an unlawful detainer. And what that means is you're going to go to the county court office and file a summons for an unlawful detainer with the county clerk. And in that summons, you're going to include your information, all of the tenant's information. You're also going to include the full amount that's going to be due, including late fees, rent, any other fees that are included that are due to you by the terms of your lease. You're going to include that in there, and you're also going to pick a court date for you and your tenant to show up so a judge can rule on whether or not the tenant is going to be evicted. Typically, those court dates, depending on the availability of the court, will be anywhere from 3 to 4 weeks to possibly further out, but usually they're no sooner than 3 weeks from the date that you file that summons for an unlawful detainer. So once you file that, you will get a copy. The court will require you to send mail your tenant a copy as well, so they are aware of it and they have the opportunity to show up and give their case. But that's the next step in terms of what you want to do after your 5-day pay or quit notice. All right. So now you have filed your summons for an unlawful detainer. The next step is to show up to the court date that you had set when you filed that summons. When you show up, you want to make sure you have pretty much anything you can use as proof that the tenant owes you money. So the number one thing that you definitely want to have is your written lease that we discussed earlier. That's the number one thing outside of anything else. If you have other documentation, feel free to bring it, but the number one thing you really need is the lease, because that is what the judge is going to look at to show whether the tenant actually does owe the money or not. Now, if your tenant does show up to this court case, the judge will call your case. You will step up as well as your tenant. The judge will ask the tenant if the amount that is owed is what they believe is owed, and the tenant will respond. Now, depending on what the tenant says here, this can really go one of two ways. If the tenant agrees that the amount owed is what is owed, then at that point, the judge will pretty much just rule in your favor and rule to evict the tenant. If for some reason the tenant does not agree with the amount that you have put on the summons or what in the court case, then at that point the judge will call for a continuation, which will basically go down a different road and set a trial date for a continuation, which could be another 3 to 4 weeks from there. Now for that, just a little side note, typically it doesn't go to this, but if that happens, us as property managers, up to this point, property managers can do everything we just discussed. However, if it gets to the point where an actual trial gets set and a continuation gets set, at that point you would need an actual licensed attorney representing you, or you as a landlord yourself would have to do it if the lease is in your name. So that's just how that works. Okay, that's just the legality of it. But let's assume 90% of the time tenants don't disagree or they don't even show up to this court case. The judge will rule in your favor and you will receive a writ of possession for unlawful detainer. Typically then, depending on the circumstance, if the house is already vacant, the judge will pretty much give you 24 hours to get that property. Or if the house or the property still has a tenant in it, at that point they will probably give anywhere from 48 to a week in terms of the time of when you can actually regain possession. So just because the judge immediately rules in your favor doesn't mean, hey, I get the property back right away. Typically the judge gives the tenant some time to get all their belongings out, up to a week, and then that's how that works. So once that happens, let's say a week goes by, the sheriff's office is actually going to be contacting you to schedule a time to meet them at the property. Now, as a landlord, you obviously want to make sure you meet the sheriff at that time, but you're also going to want to have a locksmith meet you there as well. And the locksmith is going to obviously change the locks because the tenant probably isn't going to be returning the keys. So you don't want to meet the sheriff at the property, regain possession of the property, not change the locks, because what will happen is once you go home, the tenant could show right back up and go right back into the property. So as a landlord, you want to make sure you not only meet the sheriff, but you also want to make sure a locksmith meets you there so they can change the locks effectively, regain possession, have a new set of keys so the old tenant cannot then go back into the property and basically squat or whatever they do in the property. So at that point, once you've done all that, congratulations, you have now regained control and possession of your property, and that is the proper way to evict a tenant. So if you have any questions in regards to evicting tenants in Virginia or Maryland or Washington, D.C., or property management in general, feel free to reach out to us. You can go to our website at flatfeelandlord.com or call any one of our local offices.